of them I don't remember. Yes. Is that the governor had been impeached. During his impeachment, the deputy governor assumed the high office of governor. He went to court. After a long litigation, the court found his impeachment was wrong. And then the court said, reverse the order. Just to use an expression by my learned friend, I think it was Mr. Kibago, the law is organized. The heavens didn't come down in Wajir. The law said, go back to your office, and the rest of you go home and do something else. That is how to ensure certainty, predictability, stability. That is what we should have here. We are here. I am told on behalf of the Attorney General to assure you that for as long as this matter is litigated, the law will be observed. If a day comes when anything needs to be reversed, that will be reversed. But for now, the public interest will continue. Thank you.
Yes, my lord, the leadership of my lord, let me dive right into my submissions. And I will demonstrate, my lords, that contrary to the submissions made by my learned friends, Articles 47, read together with Articles 50 and Article 25 1C of the right to a fair hearing were complied with. And I will show my lord that as of the time that notice was received in Senate by the Speaker on the 9th of October 2024, notices were issued to the petitioners to file all the documents as prescribed and to defend himself to every question that was raised in the National Assembly, which, my lord, you recall, and voted by 282 members to impeach the deputy president. The right of fair trial, fair administrative action under Article 47, and the right to a fair hearing were therefore preserved. And I will just demonstrate as I move on to show that once the 16th and the 17th were gazetted as the dates when the deputy president will be heard, and that will be Wednesday and Thursday of October 2024, the motion, the 7-day period when motions and pleadings were exchanged and commenced. And all parties were aware that the Senate investigations would take 2 days. Your Ladyship and my lords, parties were then invited to respond to every allegation. This was a two-tier trial, my lords. The National Assembly, sitting as the initial chamber that received the impeachment motion, voting in the affirmative for the impeachment motion, no brainer. The Senate, as a trial chamber, my lord, Articles 94 and 95, donating powers to Senate and to the National Assembly respectively. The Senate then proceeded to afford an opportunity. And I want to just demonstrate that Article 1(2) of the Constitution designates Senate as the National Assembly as speaking for the people under Article 1. Because the people may either accept their power directly or through their elected representatives. So my lord must read the Constitution in the sense that the Constitution then, speaking through the people, Senate was the trial chamber that undertook the trial as by the Constitution contemplated. My lord, what happened on the 16th was the commencement of the trial. And it's important to respond to this factual question. That the petitioner participated in the entire trial. Only the petitioner, my lord, had the opportunity to cross-examine all the witnesses presented by the National Assembly that presented his case before the Senate. Senate sitting as a trial chamber as a whole, and therefore as a quasi-judicial body, each senator, considering the allegations and bundles served to every senator prior to the trial. My lords, it was on the 17th, and this is an important distinction. At 2:30 p.m., after Senate had adjourned at 1:15 p.m., that Senior Counsel Paul Mwite presented to Senate an adjournment on the basis that he could not trace the petition of the Deputy President at the time. He informed the Senate that he had learned of his client's illness, but did not read it. He then sought an adjournment to 5 p.m. He had 2.5 hours to trace his client. But Lord, there's a curious point here, and this is important. The provisions of Article 145, 5 and 6, and I want to refer to those articles, provide, my lord, that at an impeachment hearing before Senate, a party may be represented. 145.5, the president, the deputy president, shall have the right to appear and be represented before the special committee during investigation. This article was wholly satisfied because the deputy president was present throughout the trial. And then Article 145, 6, A and B then step in. If the claims have been substantiated, the Senate shall, after according the President an opportunity to be heard, vote on the impeachment charges. My Lord, Senate accorded the Deputy President an opportunity to be heard. How was that accorded, my Lord? That was accorded, my Lord, first to be heard through the pleadings filed in Senate. That is one. But number two, my Lord, he was present during the entire presentation of the case. But third, my Lord, he was given and afforded an adjournment at 2:30, from 1 p.m. to 2:30. At 2:30, he was accorded an adjournment to come back at 5 p.m. My Lord, what happened at 5 p.m. is summarized at paragraphs 25 to 28 of our submissions, and it goes like this. At 5 p.m., my Lord, the Deputy President, the Counsel for the Deputy President, Senior Counsel Paul Mwite, submitted or told Senate that he could not trace his client, but that he had been admitted at Karen Hospital. He neither presented a medical report nor a report from any doctor. And that is an important observation. But beyond failing to present any document to demonstrate the truthfulness of the health status of the Deputy President, my Lord, Counsel and his team, Senior Counsel Paul Mwite, Eminent Counsel Elisha Ngoya, and the entire team proceeded to walk out. And why did they proceed to walk out, my Lord? Perhaps they did not read the wording of the Constitution and or the standing orders. Because a party, my Lord, may be presented or may be present at trial by himself or through an advocate or representative. In this case, my Lord, every opportunity was presented to the respondents to present, but they opted, my Lord, not to proceed and not to provide any document to say at that point to, my Lord, confirm, my Lord, at the point that the client or the Deputy President, that matter, was unwell and admitted. Senate then proceeded, my Lord, to vote on that question. My Lord, this is where Standing Order 85 comes in, and Rule 6 and 7. I will elaborate. Number one, my Lord, Understanding Order 85, senators on a procedural motion may vote by acclamation. That vote was carried and Senate then voted to proceed. And on the catch here is Rule 12 of the rules that govern the proceedings. Once the 16th and the 17th of October 2024 were gazetted as the days that we had to proceed, that Senate proceeded, but on the proceedings had to be sequential and could not be stopped because of the requirement that the proceedings were time bound and were to conclude in 10 days. The last day, my lord, that the proceedings were to conclude was the Saturday, the next day. My lord, unfortunately, Senior Counsel Mute, and the Hansard will demonstrate this, my lord, had applied for an adjournment to the following Tuesday. My lord, we have demonstrated that the petitioner grabbed the carpet from his own feet, deliberately decided to sabotage his own appearance when he had been in court for the in Senate for the last 2 days up to 1:15 p.m. before deciding not to be reachable by his entire team and the team making it worse by disaster. My lord, and your lordship, the petitioner had taken part in the cross-examination of all the parties. No case, my lord, has been presented before you that one, there was a violation of the standing order of Senate. That's number one. Number two, that Senate did not consider some material defense to any of the charges that were preferred against the deputy president. Lord, I just want to, for clarity of thought, submit that even on the submission that my learned friend, Mr. Masharia, made before this court, that there was additional evidence that was entertained by the speaker under Rule 6 and 7 by hearing a witness called Mr. Njomo. I remember that submission a lot. Succeeded. Only 5 out of the 11 charges. How else can Senate have been judicious? It threw out 6 charges. None of the petitions brought before you seems to commend Senate for standing its high ground and throwing out 6 of the charges. And that is what good faith would mean, my lord. That out of the 6 charges, my lord, the deputy president was convicted on the gross violation of Articles 10 to AB 27 and 129 on the shareholding remark. He was also convicted on the other grounds on national occasion and on the question that is live before this court, my lord, that is on violating this code that requires him to undertake certain functions and undermining the function of the National Security Intelligence Service. Ms. Kimodo of Kimodo and Company Advocates would want the deputy president to apologize on that count. That's a live matter. But my lord, in the grant of conservatory orders, I submit, and this is because I argued Munya, I argued Wajir, I argued Munya, I argued Mate. So I'm an authority. Yeah.
And I was with you, Professor.
Lord,
Professor, we have to
in the principle that the court considered, the Supreme Court considered in the Munya case, public interest, I think, on the scales weighed highest. That this court must take into account the import of a conservatory order issued ex parte against public interest. My lord, this is a country that is built on the Constitution of Kenya 2010 with a president whose powers are defined under Article 131 of the Constitution. And Article 131 as a writer that the president's role as the chief executive of the country shall be performed by himself directly and through delegation by the deputy president. This country, therefore, cannot contemplate an interregnum. That means space of power. An interregnum is not contemplated by the Constitution. The position of the Deputy President, my lords and my ladies, must therefore be filled at all times. And that is why the applicants know well that this country must move on and have a Deputy President sworn in because of the dictates of Article 131 of the Constitution. My lady and my lord, a conservatory order is therefore inconceivable in the terms defined in the Bunya case. A conservatory order of the nature issued by Justice Mongo is not only unfeasible, but flies in the face of principles of public interest. The interest in Meru County then was to avoid an interregnum in the governance structure so that Meru County could not collapse. And we took the bold measure to go to court at that time to protect them. This court would only use that authority to support the appointment of His Excellency Honorable Professor Ibrahim, so that this country moves to a second level. I would urge you to discharge the conservatory order on that principle alone, that the wider public interest is greater than the interest of the former Deputy President of the Republic. My Lord, wherein his images lie, right friendly about him submit, if it is a salary of 1 month, that would be compensable by damages. If it is a week salary that is 6 that I should have been or to have been Deputy President, that will be compensated in monetary terms. But this country, my Lord, cannot be at a standstill and be held through litigation, because we need to have that position free. My Lord, if I'm and Nairobi City Council the same level, and again I agree with this one. In fact, I was in this one. In this case, my Lord, the impeachment otherwise, Council on the other side submitted that there was need for a committee. Senate, in its proceedings, my Lord, in its wisdom, had voted to proceed through the whole house and accorded the petitioner all his rights that were only for the petitioner not to avail himself. Only for the petitioner not to avail himself to take advantage of the second opportunity to be had. My Lord, we submit, my Lord, that unless the processes of Senator faulted by my learned friends, the impeachment became final when the vote was taken before midnight on the 17th. And His Excellency, the Deputy President, Gachagua, stood impeached henceforth. Unfortunately, my lords, this is an impeachment which has no comeback. It is like a death. You have died. You can't come back to life. But you can have certain claims in succession. That is why we have the law of succession. Rights and remedies then come into question. My Lord, set aside the conservatory orders. Let us move on, my lords. The bigger public interest tilts in favor of the appointment of His Excellency Professor Ibrahim. A very good man. Thank you. Thank you.
My Lord and my lady, my name is Mudomi Nkolu of the Second Interested Party, and that that end, we have filed a notice of preliminary objection dated the 24th of October, the year 2024. Written submissions, telephone written submissions, telephone submissions dated the 27th day of October 2024. Before I delve into the PO, my lord, a suggestion was made to you. I forgot to tell you, my lord, that I appear for the second interested party together with my learned friend, Mr. Stephen Ogola. Before I go to the PO, my lord, a number of things were said by my friends and learned friends. I mean it because we are both friends in addition to being learned. One of the things you were told is to laugh at me for raising this PO. The other thing you were told is that the PO was determined in some rulings and directions you issued. And our simple answer, my lord, is that unless I'm mistaken, observations made by the court at the ex parte stage before full benefit of argument from all sides cannot be the subject of a submission that the issue is settled. But if you listen to me, why we have raised this PO, and you find that I deserve to be laughed at, it's okay. My lord, our PO makes only 3 interrelated points. The point number 1, which you'll find in paragraph 1 of our written submission, is that the High Court's jurisdiction under Article 23, which governs human rights litigation, and Article 165, which is about enforcement of the Constitution to confirm whether anything. I'm here to tell you very shortly, my lord, the word anything does not actually mean anything in the literal sense, and specifically to tell you that your jurisdiction under that Article 165 does not extend to disputes as to the impeachment of the president and the deputy president. Yes, the court has jurisdiction to enforce human rights. The court has jurisdiction to confirm whether anything allegedly done in the name of the Constitution is constitutional, but our submission is that that apparently very broad jurisdiction does not extend to a dispute as to the impeachment of the president or the deputy president of the republic. And that is the point made in paragraph 1 all the way to 7 of our preliminary objection. Number 2, point number 2. This court, and indeed all other courts of the Republic of Kenya, have no jurisdiction to entertain a dispute as to the impeachment of the president and the deputy president. But if we are wrong in that submission, my lord, because I have been wrong many times, we make the submission that the only court that would conceivably, arguably, mark my words, conceivably and arguably have jurisdiction on this dispute is the Supreme Court. And that is the subject of paragraph 8 of our preliminary objection. So why do we say that this court, though we acknowledge its broad jurisdiction under Article 23 and 165, does not extend to presidential impeachment disputes? The reasons, my lords, are set in paragraph 6 of our submission. And the simple point is this: that our Constitution denies this court, the High Court jurisdiction, on countless matters that would fall under Chapter 4 of the Bill of Rights. Case in point, presidential elections involve human rights under Article 38. It is clear in the Constitution that this court has no jurisdiction over a dispute relating to a presidential election. Even if someone was to come here and say that he was denied his Article 38, which is the human right under that election. My Lord, it is clear by dint of Article 58 of Article 5 that this court has no jurisdiction to hear a dispute as to a declaration of a state of emergency. My Lord and friend, Mr. Nwea talks of the word decision. We are all sufficiently decent to acknowledge that nothing invades the entire regime of human rights than a declaration of emergency. That declaration can affect the right to assembly, to expression, to basically everything. And yet the Constitution is clear. If you have a dispute as to that matter, never mind that it has abrogated the entire Bill of Rights, the court you go to is not the High Court. This is the Supreme Court. And property is a matter of the Bill of Rights. Article 40. It is clear from our Article 162 that if you have a problem in that regard, or to do with the environment, which is also a human rights matter, you go to the Environment and Land Court. So, my Lord, I'm here very humbly to tell you, the mere fact that someone has run to use screening Article 1, my Lord, in the absence of an express grant of jurisdiction on this court, on the substratum of this dispute, on the subject of this dispute, which reminds me of Professor Gideon Muige's issue about justiciability, then you have no jurisdiction. Luckily, my Lord, I hope we all agree that there is no clause of our Constitution that confers on this court jurisdiction to entertain the dispute before you. Which means, therefore, the question is whether nonetheless you have that jurisdiction, given your broad powers under Article 23 and 165. Luckily, my Lord, our Constitution was the product of a 20-year process that we call the constitutional process. And because it is in black and white, I invite you to go to page 5 of our Bado, my Lord, the Bado of Authorities. We have produced you, rather before you, extract of the Bomas constitutional, the Bomas draft constitution. It confirms to us, if you go to page 6 with me, that during the constitutional process, Kenyans actually agonized over whether these matters should be handled in the court and which court. And it's there in black and white, Article 187 on page 6. It says the Supreme Court shall have exclusive, that must mean to the exclusion of every other court, including this one. A Roman 2, disputes arising from the process of the impeachment of the president. When we were having our debates through the Bomas process, there was a decision, it's there in black and white, that there will be judicial review, not before this court, but in the Supreme Court. Of course, we know, my Lord, the Bomas draft was one of many. The next draft that was generated in that process is at page 7 of our Bado, the harmonized draft constitution. At page 8, again, clause 201 of that draft constitution, it is clear there in Article 201, sub Article 4, that the Supreme Court has, paragraph A, exclusive, underlined exclusive. We move from that document, and luckily, my lords, the bench, to me, should be familiar with this process. to a document that went to the 2005 referendum, which was a work draft. We have produced it at page 10 of our budget. This document is special, my lord, in the sense that it was subjected to a referendum before the people of Kenya. And again, you find there Article 184, Kenyans were still toying with the idea that the court can interfere in this process. But what I want you to mark again on page 11 is that the court that had been envisioned is the Supreme Court, not the High Court. We all, of course, know that draft was rejected by the people of Kenya, and that must mean, because this is a draft that reached the referendum, that the people of Kenya also rejected this rule of judicial intervention in this problem before you. Why do I say so? The next document is now the official constitution we have today, which is the Constitution of Kenya 2010. And it has no clause conferring jurisdiction on this court or even the Supreme Court. And that rule was always on the table, my lord, but was dropped from the final draft. We must take it that the final decision the people of Kenya made at the referendum of 2010 was that there will be no judicial intervention in the dispute of the nature before you. You are told that we have cited that 144, yet it is irrelevant. Let's see shortly whether it's irrelevant. We have produced that 144 on page 13 of our budget. My lord and my lady, you can only remove the president and the deputy president through two routes. Either the route of Article 144 or Article 145. We are only mentioning 144 to help us answer, in the absence of express jurisdiction, whether there is inferred jurisdiction. And when you check 144, one of the curious rules it tells you 144 at 144.8 of our Constitution is that the report of the tribunal shall be final and not subject to appeal. And if the tribunal reports that the president is capable of performing the functions of the office, the speaker shall also communicate. And of course, it goes on to hold that if it finds the president is either insane or suffers an infirmity of body, then the Senate shall vote. Something curious here, my lord, that our Senate can vote to retain a president found by a medical tribunal to be insane, and our Constitution says that decision cannot be challenged in any court or tribunal. Those are not my words. But more curiously, this rule is also repeated, my lord, in Article 165. And for me, what is notable, my lord, is the Constitution speaks to an issue once. It has spoken about this issue of 144 in 144.9, and when you go to 165 again, it says this court has jurisdiction to hear an appeal from a tribunal removal from office, except the tribunal under 144. I don't know, but it must count for something that those who drafted our Constitution decided to deny jurisdiction not just once, but twice. So the million-dollar question, my lord, if this court has been denied jurisdiction twice for the process under Article 144, on what basis can it assume jurisdiction for a process under Article 145 in the absence of express conferment of that jurisdiction, and in the face of the multiple ousters I took you through, where the Constitution says in black and white, this matter may be about the Constitution, this matter may be about the Bill of Rights, but the High Court has no jurisdiction. That's what we mean when we say in our key rule, my lord, that the Supreme Court jurisprudence in this country, I'm addressing you now, on the authority in advisory opinion number 2, I believe, of the president, through the craft of interpretation, through the craft of skill, through the craft of sophistry. Jurisdiction is something the court either has or does not have. It cannot be inferred. Professor Yende is telling me other things one must either have or not have. There is no middle ground. But I suppose he wants to fall into trouble with the court, so I won't mention it. But let's go to the decision in Nixon versus United States, which is at page 20. Again, you are told to laugh at me because this decision is from the 19th.